How to pass your wealth to your kids without the government quietly taking half or more. Many baby boomers are convinced that when they pass away, if ever, that their children are going to inherit everything they have spent a lifetime accumulating: the family home, the investments accounts, the rental properties, and the savings. The unfortunate reality, however, is that without very specific and intentional planning, the government will likely end up taking half or more of that wealth through a combination of long-term care Medicaid reimbursement expenses and higher capital gains taxes. In this video, I'm going to walk you through exactly how to prevent that outcome and how to structure things so that your children actually receive the full benefit of what you have built. Also, because so many of the families we help are global, families are blended internationally. So we have some key advice for U.S. expats, recent immigrants, along with foreign investors in the U.S. as well. Hi, I'm attorney Anthony Parent, founder of IRS Medic, and over the last 5 years, I have seen tax issues explode due to faulty estate planning. Every week, I upload new content to help you protect your family's wealth. Subscribe now so you don't miss out on critical advice like what I'm about to share with you right now. The big reasons most boomers accidentally lose more than half their wealth to the government. When there isn't a properly drafted trust in place, the sequence can be merciless. First, your family could exhaust all liquid assets attempting to pay for care of a loved one at home or privately for a nursing facility. When those assets are finally depleted, then Medicaid becomes the payer of last resort. But here's the thing, every state in the country is required by federal law to file a claim against the estate for every dollar Medicaid spent on the recipient after age 55. So what remains for the children is often very little, and in many cases, nothing at all. It's estimated that 70% of baby boomers will need long-term care, so this is critical advice. So here's the reasons they will lose everything they managed to hang on to. Many estate planning attorneys do not understand the capital gain consequences of the trust they draft. When a trust or a transfer is structured incorrectly, the children lose the step up in basis they would have received if the asset had remained in the parent's name. Now, this might sound complicated, but the result is simple. When the children eventually sell the family home, they owe a massive capital gains tax on what could be decades of appreciation, could be 6 figures, even a 7-figure tax bill. And you know what? It could have been totally avoided. So I will share with you the 2 magic words that will stop this problem dead in its tracks. But first, let me explain the one legal tool you will likely need that many attorneys draft incorrectly. The solution to Medicaid recovery is a properly drafted, irrevocable Medicaid Asset Protection Trust. When this trust is drafted with precision, it accomplishes 4 objectives simultaneously. First, it removes the home and other assets from the Medicaid spend down calculation after the 5-year look back period has passed. Second, it completely blocks Medicaid state recovery because the assets are no longer owned by the individual at time of death. Third, when the trust contains the correct tax language, it preserves the full step up in basis at the time of death of the second spouse, if applicable. Fourth, it allows the children to inherit and later sell the property with little or no capital gains tax consequences. And from a day-to-day perspective, a Medicaid Asset Protection Trust changes very little for the parents. They continue to live in the home, pay the real estate taxes, maintain it, and enjoy it exactly as they always have. The only thing that changes is the legal title, which is now held by the trust. Okay, let's get to the 5 questions you must ask to determine whether or not your current plan is safe. All right, so take whatever trust or estate planning document you have or your parents have and get it up here. Let's go through it. If the attorney cannot answer each question clearly and immediately, you might want to get a second opinion. So first, is this trust truly irrevocable, or is it revocable? A revocable trust provides zero Medicaid protection. 2, does this trust preserve the full step-up in basis at death or death of the second spouse? 3, for income tax purposes, is the transfer into the trust treated as a completed gift, or, here's the 2 magic words, incomplete gift? How are the rights to income and principal separated, and who retains control over each? And 5, exactly how does this structure affect Medicaid eligibility once the 5-year look-back period has been satisfied? Look, a simple will not help you. A standard revocable living trust is insufficient. You must have one integrated document that provides both an ironclad asset protection and precise income tax basis planning. Okay, let's get to some mathematics, and that should motivate immediate action. So here's a real-life example that I promised. Calvin was about to put his house he bought for $100,000 in 1991 in a Medicaid trust. He was going to convey the entire property, but he watched this video, so he learned that his kids will be paying the capital gain that occurred from 1991 until his death. Right now, the property is worth $1 million, so his kids are looking at a capital gain tax of at least $200,000. So in order to avoid this punishment on his kids, Calvin put his house into the trust, but reserved a lifetime right to use the property. This tiny move, this incomplete gift, just saved $200,000. Now some words. If you don't live in a U.S. state, Medicaid won't likely be an option for you, as Medicaid is a federal program but is administered by the states. Yet, if you live overseas, there is even another trap to be concerned with. Many of our clients overseas are married to non-U.S. spouses or have a non-U.S. person somewhere in their family or estate plan. And here's the trap to watch out for. Be aware if there is U.S. property and if it's going to be owned by someone who is not a U.S. person, because a federal estate tax kicks in at just $60,000. Any assets over that are taxed at 40%. If you have global assets and are part of a global family, your estate plan needs to keep up. And interestingly, there has never been a time when so much wealth has been so global. Passing your wealth to your children should never result in the government becoming the largest beneficiary of your life's hard work. I placed a direct link below to my completely free checklist, Don't Let the Government Inherit Your House. Download it, use it, and take this action this week. In the next video, I'm going to reveal why the federal and state governments are quietly positioning themselves to be the largest beneficiaries of the $84 trillion great wealth transfer that is already underway. This is Anthony, parent with One Team Legal and Tax, IRS Medic. Thank you for watching, and I will see you in the next video.